You see it come to order, this court is now in session.
Afternoon. The matter of the people of the state of California versus Elizabeth Broderick. Court finds all members of the jury panel are present. Two of the three alternates are present. Mr. Schmidt waived his right to be present for these proceedings. All counsel are present. Mrs. Broderick is present. Mr. McAllister, I understand the jury has reached a verdict.
Yes, that's correct.
Would you give the forms to my bailiff, please? Clerk can read the verdicts.
In the Superior Court of the State of California and for the County of San Diego, the people of the State of California plaintiff versus Elizabeth Ann Broderick defendant, Department 28, case number CR 112048, DA number B68588, verdict. We, the jury, in the above entitled cause, find the defendant, Elizabeth Ann Broderick, guilty of the crime of murder in violation of Penal Code Section 187(a), a felony as charged in count 1 of the information, and fix the degree thereof as murder in the second degree. Victim, Daniel Broderick. And we further find that in the commission of the above offense, the said defendant did personally use a firearm within the meaning of Penal Code Section 12022.5(a). Dated December the 10th, 1991. Presiding juror, George McAllister. In the Superior Court of the State of California and for the County of San Diego, the people of the State of California plaintiff versus Elizabeth Ann Broderick defendant, Department 28, case number CR 112048, DA number B68588, verdict. We, the jury, in the above entitled cause, find the defendant, Elizabeth Ann Broderick, guilty of the crime of murder in violation of Penal Code Section 187(a), a felony as charged in count 2 of the information, and fix the degree thereof as murder in the second degree. Victim, Linda Broderick. And we further find that in the commission of the above offense, the said defendant did personally use a firearm within the meaning of Penal Code Section 12022.5(a). Dated December the 10th, 1991. Presiding juror, George McAllister. Ladies and gentlemen of the jury, were these and are these your verdicts as I read them?
Surely want the jury polled as to each count.
Your Honor, the court could poll them as to both counts together.
All right. Clerk poll them as to both counts. Yes, one polling as to both counts. All right, let's record the verdicts. Waive ratings recorded.
Yes.
Yes, Your Honor.
Ladies and gentlemen, at this time I want to thank you for your service as jurors on this case. Service as a juror always interrupts everybody's daily routine, but when you serve on a case that's the length of this one, it calls upon you to make substantial sacrifices and adjustments in your daily schedules. So on behalf of the lawyers and my colleagues and myself, and most importantly, the other members of this community, I sincerely thank each and every one of you for the time you've devoted to this case. You probably think I watch the ceiling lights a lot and don't pay attention to what was going on, but I did notice that you folks took a lot of notes. Some of you I know were on your second notebook full of notes. So I am aware of the fact that you were very attentive, and I sincerely thank you for your service in this matter. I particularly want to thank the alternates, Mr. Sheely and Mrs. Scott and Mr. Schmidt in his absence. You probably have the hardest job of any of them because you don't get to state your opinion. You have to listen to everything and pay attention, as I know you did, and you don't get to vote. So I know you had a tough job. I appreciate the fact that you were willing to serve as alternates and that you did, in fact, pay as much attention as I know you did. And I thank you extra special for your willingness to serve in this matter. At this time, ladies and gentlemen, you are, of course, released from your admonition not to discuss the case with anyone. You can discuss it with anyone that you want. However, it's important for you to know that you're under no obligation to discuss this matter with anybody. Attorneys or representatives of the attorneys or the press will most likely want to talk to you if you want to talk to them. I would only caution you that if you decide to talk to anyone about this case, that you say only what you'd be willing to say in the presence of other jurors or in this courtroom under oath. I'd also remind you or ask you to consider your fellow jurors that they express their opinions in the jury room in confidence and in the confidentiality of that jury room. So if they want to express their feelings, I would request that you honor their personal opinions and let them decide whether or not they want to say how they felt. If you want to discuss how you felt, that of course is up to you. But I would ask you to consider the out of thoughtfulness and respect the views of your other jurors and let them decide whether or not they care to make a statement. Along those lines, ladies and gentlemen, I am sure that members of the media and the attorneys are going to want to talk to you. What I intend to do is in a few moments release you to go back to the jury room to pick up your personal belongings. I'll then make my courtroom available in approximately 15 minutes for members of the press and any of you that want to be interviewed or make a statement or whatever, or if you want to have a representative or whatever you want to do. Again, you're under no obligation to do anything, but I will make the courtroom available so that you won't be hopefully bothered at home or otherwise if you desire to make a statement. So my bailiff, in about approximately 15 minutes, would let you back into the courtroom where you can make a statement if you so desire. And again, you're under no obligation to do that. At this time, I would again thank you for your service as jurors in this matter. If you follow my bailiff to the jury room to pick up your belongings, please. By Mr. Early with this court on February 5th of this year. There has been no written response filed by the district attorney, I assume because of the timing of the filing of the motion. Do the people want to respond orally, or do you want time to file a written response?
Yeah, for the record, Your Honor, I can indicate that I personally did not receive this motion until yesterday morning. Obviously, with only a day before the sentencing, I do not have time to file a written response, but I don't want to put the sentencing over. There are several people here from out of state and out of the country, in fact. So I do intend, if with the court's permission, to simply respond orally.
Agreeable with me. All right, Mr. Early. Proceed.
Your Honor, since I have presented papers with my position at this time, maybe it would seem to be appropriate if maybe just responding to whatever the district attorney's position is on the moving papers.
I think that's a great idea.
That's fine. Go ahead.
And I apologize if I'm a little bit unorganized, Your Honor, because of the lack of time to prepare for this. But first of all, I'd like to just comment about the statement of facts that's included in that motion for new trial. I should say it's a statement about allegations. This statement of alleged facts in this motion is, in my mind, just a patently propagandized account of the defendant's version here for the obvious benefit of the press and probably ultimately for the benefit of the parole board. It can hardly be considered an accurate statement of the evidence that was actually presented at the time of the trial. I don't think it's worth going through paragraph by paragraph to point out the problems with the factual nature of that statement of facts, because I know this court heard the evidence. I know this court, which is the only person that matters at this point, has the ability to wade through that statement and determine what the relevant truth is. And ultimately, the parole board is definitely going to get the whole story. So with that objection in mind, the first claim that's made by the defense is that the court erred in limiting Dr. Sonkin's testimony. I think it's important to point out, as the court well knows, that Dr. Sonkin was not precluded from testifying to begin with. He was simply limited to testifying about relevant evidence, which is obviously as it should be. Contrary to the defendant's claim, Dr. Sonkin was allowed to testify to the basis of his opinion. He was allowed to testify in its entirety about his interview with the defendant. He was allowed to testify about his opinion, and that his opinion was based on anything that he considered, the reports, the interviews that he considered. The only limitation that the court placed on Dr. Socken was that he could not testify to specific hearsay that was otherwise inadmissible. And that's because that's the law. The people cited the case to the court during the trial, People versus Coleman, which is the California Supreme Court case that holds that that's the law. Obviously, it was a correct ruling by the court. It was proper for the court to limit Dr. Socken's testimony to his opinion regarding emotional abuse for one very important reason, and that is because there was no evidence to support anything else. There was no evidence, none, zip, zero, about any sexual abuse committed on the defendant by her own admission. There was no evidence about any physical abuse post-separation for the 4.5 years prior to these murders. There was, in fact, no evidence of any actual abuse during the course of the marriage. And that was not just by omission. The defendant specifically testified that Dan Broderick never intentionally struck her. Clearly, the court can make a determination on relevance and on 352 grounds to limit such testimony. In addition, the offer of proof about Dr. Socken's testimony included nothing about him testifying regarding the defendant's actual mental condition at the time of these homicides. The defense claimed that his testimony was relevant to show her state of mind, quote, during the marriage and during the separation. Her state of mind during those time periods was not an issue. The issue was not what caused this defendant to ultimately decide to kill Dan and Linda Broderick. The issue was what was her actual state of mind at the time of the killing. She testified about her state of mind. She testified that it was one of contemplating suicide because she was frustrated or allegedly frustrated over not getting custody of the boys and all of the things that had been happening during that fall leading up to that night or that morning. The defense themselves claim that over the summer, for a long period before that time, that there was no problem with the defendant emotionally, that she was doing much better, the marriage was long over, the divorce was over. Whether Dr. Socken believes, and by the way, I should point out that Dr. Socken, who is not even a licensed psychologist and who has a degree from a mail order college, his opinion was very strongly disputed by several prosecution witnesses who were not ultimately able to testify because he didn't testify. But it was their opinion that the defendant didn't even come close to fitting the criteria for suffering from battered woman syndrome. Whether Dr. Socken himself believed that she'd in some way been abused during the marriage years before was totally irrelevant. He also, and I know the court recalls this, he specifically said that he would not be testifying about any emotional abuse caused allegedly by way of the divorce process. He had no opinion regarding that. His opinion only related to her testimony, or her treatment, during the marriage. Our position, obviously, at the time was that his testimony was entirely irrelevant. He should not have been allowed to testify at all. The court did not rule in our favor. The court ruled in the defense favor. The court, I believe, actually gave the defendant more than she was entitled to by law. Dr. Socken was allowed to testify regarding his opinion that she had suffered emotional abuse during the marriage, the basis of that opinion, and what the effects of it were. Elizabeth Broderick was allowed to testify and did testify as to what allegedly had been done to her to constitute that abuse. There is no error by the court's ruling. One last point with respect to Dr. Socken. His testimony, if relevant at all, even by the defense's own concession, was relevant on the issue of premeditation and deliberation only. It was not admissible for consideration for heat of passion, and the court would have given us an instruction to that effect. Given the jury's verdict, this issue is moot. The jury convicted the defendant of second-degree murder. They could not have considered this evidence to reduce that murder to voluntary manslaughter. The issue is moot. The second basic claim by the defense in their motion is this sort of all-encompassing claim that regarding evidence of Dan Broderick's state of mind. And they state in their papers that there was no limits on the prosecution in presenting state of mind evidence regarding the victims. Well, maybe I was involved in a different trial because that's ridiculous. There are probably 50 witnesses out there that could have related Dan Broderick's feelings about this marriage and what he was going through in this marriage and in this divorce, about his feelings about the defendant's emotional rejection of him, about her demands, about her temper tantrums, to put some of this in perspective for the jury. We didn't get to do that. We had his entire deposition testimony that explained and disputed all of her claims of his alleged misuse of money. We didn't get to put that in perspective. We had his entire divorce trial testimony, which was extensive. It covered several days, that gave an entirely different side of the picture that was being portrayed by the defendant. A very enlightening different side, and we weren't allowed to do that because his state of mind regarding his feelings of the marriage, the divorce, being the victim of constant harassment by the defendant was deemed not relevant. I can also recall specifically the court sustained several hearsay objections during the testimony of Kathy Cafaro, which is what the defense now objects to. We were not allowed to present any of the numerous conversations that Dan Broderick had with Kathy Cafaro regarding his concerns for the children and what the defendant was doing to them, regarding his despair over not knowing what to do about the situation, regarding his reasons for not filing the contempt actions, regarding what had been related to him by the boys about the defendant's threats and carrying the gun and showing the gun to them. None of that came in. We were not allowed through Dr. Sparta to have him testify about any of the conversations over a span of 4 years that he had with Dan and Linda Broderick regarding their concerns for the boys, to explain why they had a concern about giving the defendant custody of those children. We were not allowed to introduce Dr. Sparta's opinion based on dealing with this family for 4 years, that Dan Broderick was not mistreating these children, not even close, that it was Elizabeth Broderick who was so emotionally abusive to them that he reported her to Child Protective Services, something that he's maybe done once or twice in his entire career. We were not allowed to present any testimony from several witnesses who had conversations with Linda very shortly before these murders about her fear that the defendant was getting ready to do something, about the fact that things had been moved in the house and she was fearful of that, about the fact that she'd been confronted by the defendant in the house only a short time before these murders, about the fact that she was terrified. There were significant limits placed on the people regarding the victim's state of mind. What the defendant does here in this motion is basically just simply re-argue the arguments that were made at trial. With respect to the purported testimony of several witnesses, several last-minute witnesses, and the court did not err in excluding any of these. And I want to comment just briefly on each of them. With respect to Paul Taylor, even if what the defense says he says is true, and from what we know about his character and background, I submit that there's substantial reason to doubt his credibility. The fact is that it's completely irrelevant because it could have no effect on the defendant's state of mind. She knew nothing of it. It was something that was alleged to have occurred, if it did occur, 6 to 7 years prior to these murders. The defendant consistently also misquotes what Paul Taylor said in his statement, which was that Dan Broderick never solicited anyone's murder, that he did not raise the issue of money, and that his last statement was, "I would never do anything like that anyway because it's illegal." What's the relevance of that for the defense? With respect to the statements made to Steve Griffin, those were excludable properly on at least 3 grounds. One is that the defense did not comply with the court's discovery order. The court obviously has the right to impose sanctions for that, as they did not with respect to Paul Taylor. Rather than promptly turning that information over to the people, defense counsel instead attempted to, by asking a question that he knew the answer was no to, improperly get information before the jury. That was improper. And everyone knows that if the people had done a stunt like that, the court would have granted a mistrial like that. We had no recourse for that type of improper conduct. And the court could have ultimately kept any of that as testimony out for sanctions, even though I know the court didn't make its ruling on that ground. It was not newly discovered evidence. None of this was Steve Griffin or Paul Taylor. It was evidence that the defense was attempting to keep secret, to produce by ambush. They didn't want to follow the rules. In addition, the statements made to Steve Griffin are obvious textbook hearsay offered for its truth with no ability to rebut because Linda Colquina is dead, and they don't qualify under the state of mind exception. Linda's state of mind regarding whether or not these allegations made by the defendant are true, her state of mind is not relevant. There is no hearsay exception. The defense wants to say that there's some exception that says that, well, if it corroborates what someone else thinks is true, then it comes in. That's not the law. The declarant's then existing state of mind must be an issue, and it is not. With respect to the alleged statement that was made to Steve Griffin in May of 1989 regarding using the legal system, that's also misleading by the defense. The fact is that, at least according to our interview of Mr. Griffin, Linda did say that, yes, they were using the legal system against Elizabeth Broderick because that's all they could do. And yes, they were hoping that finally by doing that, she would stop her harassment and leave them alone. It's an oxymoron to say that by using the legal system, which is what they're supposed to do, somehow that would constitute legal provocation for these murders. It's not relevant. The statement from this man from San Mateo, who we have never received discovery on and have not had an opportunity to interview, again, obvious hearsay offered for its truth. The conversation alleged to have occurred sometime in 1983, 6 years before these murders. A conversation that the defendant acknowledges she knew nothing of. The witness apparently can't even positively identify Dan Broderick as the person who made the statements. In addition, what is claimed by those statements is what's important about it is not what might have been being thought, but what actually occurred to make it relevant. And the fact is that Dan Broderick did not drag Elizabeth Broderick through the system. Even her own attorneys say, all of them say that it was the defendant who wouldn't settle and who caused the proceedings to drag on and on and on for her obvious motives. The fact is that Dan Broderick did not take her children from her. If that had been his plan, he would have done it, and he didn't. He left the children with her, and she intentionally gave them to him. There's no relevance to the defendant's state of mind on the morning of these killings from this evidence. The evidence regarding Linda and Delta Airlines. My recollection is this was never offered by the defense. I don't know where this comes from, that there was claiming that there was some error by the trial court not letting this evidence in. Maybe I'm wrong and the court can point it out to me. I don't recall the defense ever offering it. Even if they had, it is so incredibly not relevant that I don't even think it's worth responding to. It is patent character assassination. I mean, give me a break. We might as well go back to Linda's junior high school records to find out whether she ever cheated on a math exam or ever came in late after curfew. There is this new purported relevance about her feelings about bad language is ridiculous. And finally, this alleged witness, unnamed attorney, regarding conversations with Dan and Linda and their property, I've never heard of. We received no discovery of. As my recollection is, it was never offered during the course of the trial. There was never any request to put on any such evidence. And beyond that, it's hearsay. It was unknown to the defendant. And even looking at it from a matter of practical logic, even if it's true, their state of mind, which was apparently to keep this information secret, couldn't possibly support a claim that they were doing these things intentionally to provoke the defendant. It has no relevance. In my opinion, this court bent over backwards to give this defendant a fair trial and to allow the defense to put on their evidence. She got to tell her story, the jury got to hear it, and it was not just left to be viewed in a vacuum as the defense claims. They got to put on both Dr. Lusterman and Dr. DeFrancesca to put her conduct in context with her emotional or her psychological state. Nothing that the defense argues is new in this motion. Nothing about anything cited should cause this court to question its original rulings, and the motion should be denied.
As well, Sterling.
Your Honor, it appears to be that the attack has shifted from not only Elizabeth Broderick, but to the defense itself in late coming discovery. It's interesting that at the time that I asked for hearing and for these witnesses to be present so that they could testify as to the true state of the facts, not only did the district attorney object to that because they did not want the court to hear the truth of these statements, but the court would not even hear from the witnesses. The district attorney now alleges that they have had interviews and tries to get the court to make the decision on a different basis and set of facts than the court was given, where we've been provided no discovery as far as any interviews. The district attorney was provided discovery of these witnesses at the time. These witnesses came forth in the middle of trial. They came forth in October. They came forth after hearing from watching, as it happens to be, Court Network TV, seeing what the position of the district attorney is, seeing what the truth of the matter was and the information they had, and they came forward to the defense. The district attorney got that information within a week after we had an opportunity to investigate that information to find out if it was true. And now the district attorney comes forward and says that the information that we had and that we brought forward wasn't true after they did not want to have a hearing. Again, the district attorney feels that the best way to look at this motion is to attack Dr. Zonkin and to talk about necessarily where he went to school and to characterize a school that has a very good reputation as a mail order school, which is nowhere near the truth in this matter. The problem with Dr. Zonkin's testimony is we sat here in court, we went through it line by line by line. We took 50 pages of trial transcript from the first trial and reduced it to 2 pages. Reduced it to 2 pages where Dr. Zonkin had to divide out testimony as to emotional abuse and say, how do you divide that from the physical and sexual abuse that had been going on for years? The district attorney first says that there was no foundation for the sexual abuse. They ran a motion before trial that said, we don't want this evidence to come out. We think it's irrelevant. The court sustained that. They directed Mrs. Broderick not to talk about and not to testify about those items. And then they come in and they complain that since they objected to it and they kept it out, that it can't be true because we didn't present it. As far as saying that there's no foundation for physical abuse, Dr. Zonkin testified that physical abuse can be in fits of anger. There's no doubt that there was a number of witnesses that came and testified about Elizabeth Broderick appearing with black eyes, about Mr. Broderick tearing doors off of garages, slamming things around, kicking the dogs, screaming at the children, pounding the walls, grabbing Mrs. Broderick, asking her if she wants to be next. And then they say that that is not physical abuse. Well, maybe to the district attorney, that is the kind of civilized behavior that we should have in marriages. But anyone else would say that that is a form of physical abuse. And to go through a marriage of 15 to 17 years of abuse that starts at the beginning and continues on, and to say to somebody that you have to try to separate the effects of one form of abuse without the other is an impossibility. And Dr. Zonkin said, you cannot do that as an expert. You cannot look and say that here are the effects, and I can tell you that this form of abuse or this act of abuse caused this effect. They're all interrelated. The problem that we had with presenting evidence is Mr. Zonkin was allowed to say that I based it on interviews, I based it on police reports, but was not allowed, and when we went through line by line, to go into detail about what he based it on, what Elizabeth Broderick told him, what the interview said. It was interesting that when the district attorney had their doctor on the stand, that they went through asking lots of questions, even when I objected to him, about what did you read in the diary? What did this person tell you? What else what other information did you have? And went into detail, at least at the information that they had about that time, about Elizabeth Broderick. The truth of the matter is that Dr. Zonkin's testimony was left for him to get on the stand and say, I have an opinion that she was suffering from emotional abuse. I can't tell you what I based that on. I can't tell you what else it was involved on. And I can't really tell you about what the effect of that is. He was not allowed to give any information as to corroborating evidence. And the district attorney is right as far as Coleman saying that the court has the discretion to decide whether a doctor can rely on hearsay. It doesn't say that all hearsay cannot be relied upon by the doctor, but the court has to look at the hearsay, the reliability of the hearsay, and the court then has to make a determination, is that something that someone can normally rely upon? Does it have any area of truthfulness at all? So when we go into the conversations he had with family members, the ones he had with neighbors, when he goes in and the threats that Mr. Broderick made about the neighbors, about saying things about him that weren't true when they spoke badly about Mr. Broderick, those things, yes, are hearsay because the witnesses aren't allowed to testify. But Coleman does not say, and none of the cases say, that you cannot rely upon him or that you cannot bring him in. The court has to use discretion. And I don't believe that it's complete discretion for the court to say that none of those will come in at all. I think the court has some duty to look to see what, how those issues, or at least which hearsay should be admissible, or what instances should be admissible, and which ones that a doctor would use normally in his opinion. I don't believe the issue is moot. There is a law in California that when you are talking about a battered woman syndrome, when you're talking about the elements around it, that is admissible without limitation. It doesn't say in the law that it's admissible only to premeditation and deliberation. What the case law says is that psychiatric testimony, yes, has been limited as to what it can be considered for both by the court and a jury, unless there is a statute, and there has been a statute by the legislature. And this Supreme Court, with a statute, does not have the ability to say that they will not follow that law. I believe that there was obviously, Dr. Zonkin's testimony was important at the first trial, and I believe that it was part of the testimony that should have been admitted in its full in the second trial. The district attorney goes through, and it's interesting that the district attorney complains about this late date of the witnesses that they wish to call, but they never attempted to call those witnesses. They never made an offer of proof to the court. We never had a hearing on that. The very beginning of the trial, I told the court, I think this case, they should let all hearsay in. They should let everyone take the stand and let the jury hear from every witness that has something to say on this case. Let them come forward. They could have brought in as much character testimony as they wanted to. But the district attorney knew that by bringing what they called the character evidence in, they would be faced with the fact that there was lots of testimony out there. There was a lots of truth to rebut that. And the district attorney said they were limited. They weren't limited. They were limited by the fact that the defense had evidence that would have shown and would have balanced the picture that was being presented by the district attorney. The district attorney, interestingly, in their opening statement, brought in the fact of Linda Colquina, where she worked, that she was a paralegal trained in Atlanta, that she worked for Delta, that she left there to become a paralegal. She never introduced the evidence, and the reason that she didn't introduce the evidence was because she was trying to bring it in before the jury, but she didn't want all of the evidence in. She didn't want that to be balanced. She wanted a jury to believe a particular set of facts that weren't there. She argues in this statement that she was not allowed to bring in a statement that Linda Colquina said that Elizabeth Broderick had come into her house weeks before the homicide and was very afraid of Elizabeth Broderick. Well, the true state of facts is it would have welcomed to bring that statement in, because it was an allegation during this trial that Linda Colquina had been spreading rumors about Elizabeth Broderick, that she was out to destroy her. And isn't it interesting that when they file a contempt order through their own law office where she works, and they bring up 2 phone calls from Elizabeth Broderick, they don't put in the moving paper that Elizabeth Broderick 2 weeks early broke into their house in the middle of the night and confronted Linda Colquina. Not only could have they called the police, and that would have been a crime, but it would have been the first statement they would have made in an order to the court to show contempt. There was a restraining order, and if there was any truth to those statements, they would have been brought forward. But the district attorney didn't bring them into court because it was nothing but the history of the case. And now, at this late date, when the district attorney never tried to introduce it, she tries to tell the court that it was balanced because she didn't bring those things in. It was never offered to the court. The whole litany of items that she brought in and that she said that she would have liked to introduce, she never tried to introduce them. Stephen Griffin was denied under Prop 115. We got that information 1 week before we tried to present that evidence. And the district attorney said, and the same with Paul Taylor and Steve Smith, we gave it to them 2 days after we got the information. We're able to find out who he was and where he worked and was he actually a deputy district attorney. And
I've never received any information about Steve Smith.
Your Honor, we had a hearing. I made the offer and they asked for discovery and I gave them the notes at that time. We had a hearing in court. This district attorney has never come into this court and not demanded discovery. And it's hard for me to believe that when we had a hearing and made an offer of proof that the district attorney is saying, I just never asked to see a statement.
No, I'm not saying that. I'm saying I never got a statement. I never got any discovery.
Whether she got discovery, there was an offer of proof made to the court. The court made a ruling based on the offer of proof. The court made a ruling on the offer of proof. But it was still, the district attorney makes allegations that we were laying in the weeds. We were hiding. This is something that we had found out that we came to the court 2 days after we got it, when we were able to find it. The lawyer that Linda Kolkina and Mr. Broderick went, we came the next day to the court. Paul Taylor, we came as soon as we checked those items out. And the interesting thing is when the court ruled that the district attorney, the reason that they were not going to allow the statements in from Steve Griffin was because the district attorney on cross-examination asked Elizabeth Broderick, why would Linda Kolkina want to mail these items to you? Why would she want to mail wrinkle cream commercials? Why would she want to mail the tablet out to you with the statement, eat your heart out, bitch? When we saw the other statements from Linda Kolkina that had the same kind of yellow tab, that derogatory towards Elizabeth Broderick, that we knew came from her. But the interesting thing is the district attorney said, you knew I was going to ask the question. Wasn't concerned that she was asking a question that had no truth to it. And maybe the jury should know the other side. But said, you should have known I should ask the question. At the first trial, she never asked that question of Elizabeth Broderick. She never said to Elizabeth Broderick, how would you know? Why would Linda Kolkina do that? She did argue it in her argument, but she never asked that question. So the ruling that the court made that somehow I should have known that she was going to ask a question that didn't represent a true state of facts and is an improper question to begin with of Elizabeth Broderick, why calling for speculation? The court ruled that information doesn't come in. And there were other remedies available. The court could have instructed the jury that this item was supposed to be turned over and wasn't turned over for 5 days, and somehow the district attorney asked the question that wasn't there. There's a lot of other remedies that the court needs to go through. Those statements were not gone through. When you look at the cases that I cited in my moving papers, it's clear, and there's a lot of case law that talks about victims who are called victims in instances like this, in self-defense cases. It's clear that their state of mind is at issue. Did they act in conformity with? And that's 1250. And 1250 does not say self-defense cases. It said if the person or the victim's conduct is in issue, there is an exception to the hearsay rule if they make a statement that shows their present state of mind, and if it's relevant to the issues of the case. Our defense in this case was provocation. In the Coleman case, in the Hamilton case, and other cases, provocation has, when they've given examples of what a person's state of mind is that you can prove under this exception, one of the things that is mentioned is provocation. And a district attorney misses the point when the district attorney says Elizabeth Broderick needs to know what these statements are. That's not what 1250 says. 1250 says that if it's hearsay, but it shows a then existing state of mind, then that is an exception to the hearsay rule and it is admissible. What I said in my moving papers is that Elizabeth Broderick was married to Dan Broderick for 15 years. He told her how he practiced law, and she testified to that. He told her how he liked to destroy other people through his law practice, how he either liked to humiliate him or attack him, serve him in a church. He liked to send him nasty grams. He thought that was effective. And what she talked about is, knowing that, exactly what she felt Mr. Broderick was doing to her. The reason that I mention that in my moving papers is it clearly shows how important this is to show his then existing state of mind. It wasn't just Elizabeth Broderick saying this. This is Mr. Broderick saying to it. And the district attorney says that maybe this deputy district attorney from San Mateo County is a flaky witness. Maybe they shouldn't be listened to. Maybe they shouldn't be here. Maybe it's unreliable. I don't know if that's their position. The thing that's interesting, in 1983, why would Mr. Broderick say that he was going to drag her through the system, he was going to make it go on, that he was going to take her children away? He talked about a gun then. He talked about making it look like suicide. And when you look at that, that's exactly, at that point in time, what happened. Later on, I mean, that's exactly the plan that was followed. And it shows his then existing state of mind, what he was going to do. Mr. Broderick was a very intelligent man. He wasn't going to go into the court and say, this is what I plan to do. He wasn't going to tell the court this. I want your orders, or I want to do this because this is what I plan to do. But he didn't know at that point in time that those statements at some point in time would surface during this period of time. I think that those statements all go to then existing state of mind. The court, and if the court will recall, a security guard testified at the trial. The security guard said that he guarded the wedding. What the court allowed in is why he did that. And that was a conversation with Mr. Broderick, and it was because Mr. Broderick had a fear of Elizabeth Broderick. And he had a fear of what she was going to do and how she's going to disrupt the wedding. The court just said that's foundation, but it's hearsay. And what that foundation does is it shows his then present state of mind to explain his course of conduct. When Kathleen Cafaro got on the stand to testify, she testified in part as to some of the conversations she had with Mr. Broderick as to why she was filing certain pieces of paper. Those all came in, as the court called it, foundation. But when you look at it, the only reason they could come in is to show the state of mind. They're clearly hearsay. And the foundation is to show why he acted in a certain way. And I believe that the jury, getting that only representation, deserved to have the other side. Whether they believed one side or the other, whether the district attorney had 20 other witnesses that were friends of Dan Broderick to say otherwise, I think that those witnesses should have been presented. Stephen Griffin, in the offer of proof, the district attorney again brings up what he would say, hopefully now for the district attorney, even though they haven't provided discovery. But the offer of proof was that he had a conversation with Linda Kolkina, or Linda Broderick at that time, in May of '89. And the offer of proof was that they were still going through the divorce process, that they talked about the fact that it's not good to attack an ex-wife. It makes things bad. And she said that we were a law office and it doesn't cost us anything. And if we keep dragging her through, she'll finally give up and go away. Again, we asked for a hearing on that. We were confident of what the witness will say. The district attorney also objected to that hearing and now wants the court to consider a different state of facts than was presented at the hearing. All I can ask the court is to consider the hearing that the court had, the offer of proof that was made to the court, because that's what the state of evidence is. And I think that when you look at the verdicts in these cases, in this case, I don't think the court can say that evidence was not important, that obviously the jury rejected premeditation and deliberation. I think we have to look at that from the verdict. And that testimony was not allowed in And I believe that that testimony would have had a profound effect upon this jury because it profoundly explains the situation as we have it. It casts a light that does not just put Elizabeth Broderick saying, this is what I believe, but it puts it that this is what I believe, and this is what Mr. Broderick said that he was going to do. I think that that when the court looks at all of the evidence, and I realize it's from hindsight, but when the court looks at it, looks at the verdict in this case, I think that the only conclusion is that there was error, that the jury not be able to have those tools to be able to have a whole picture to decide whether to accept or reject the defense that was presented in this case. And for those reasons, I would ask the court to grant our motion for a new trial.
Thank you, Mr. Early. Ms. Wells, you want to respond?
I'll submit it, Your Honor.
Well, as has been summarized by both counsel, there are really two basic bases that are being alleged for the new trial motion. The first was my restriction of the testimony of Dr. Sonkin. Dr. Sonkin testified at the first trial that in his opinion, Mrs. Broderick was the victim of sexual, physical, and psychological abuse. After listening to all the evidence of the first trial, I informed both counsel before this trial started that I was going to have a 402 hearing with regard to foundational facts as to sexual or physical abuse because I found them to be lacking in the first trial. We had that hearing at the time, or at the conclusion of the hearing, I ruled that he could not testify as to sexual or physical abuse because I found there had been an inadequate showing of any foundational facts to support those opinions. In fact, with regard to physical abuse, the testimony at the trial was exactly the opposite. First, as pointed out by the district attorney, Mrs. Broderick herself testified that she was never intentionally struck by her husband. There were 3 incidents of physical contact that were mentioned at various phases of the trial. First had to do with a skiing incident where Mrs. Broderick apparently ran over the tip of the ski of Mr. Broderick and he shoved her down. That was before the marriage and clearly wasn't relevant to anything that happened during or after the marriage. There was what Mrs. Broderick herself described as an accidental or unintentional striking of his elbow or upper arm or forearm that hit her in the eye and caused a black eye. She regarded that as an accident. That is the only incident that I recall being testified to that took place during the marriage itself. After the marriage, there was a third incident that was directly related and took place immediately following the time when she ran her car through the front of the door of the house on Cypress Street. It was at a time when one of the daughters, I believe it was Kathy Lee, was standing between her mother and Mr. Broderick, and she was trying to strike him with keys that she had in her hand. He shoved her away. At best, or at worst, that's self-defense, and certainly, since it occurred after they were separated, certainly wouldn't be considered a battered women's syndrome, in my opinion. Another fact that we haven't mentioned is the fact that during the interview with Dr. Sonkin, the defendant told Dr. Sonkin that she did not consider herself to be a battered woman. I ruled, therefore, that the doctor could not give an opinion or render an opinion on a condition to which there were no foundational facts. It's my understanding that that is the law. I am comfortable with that ruling. I did not rule that he could not testify with regard to psychological abuse. I did not rule that evidence of psychological abuse could not be presented. I did not rule that evidence of a battered women's syndrome could not be presented. I would note, as has the district attorney, that Dr. Sonkin had no opinion as to what effect, if any, psychologically that the the dissolution proceedings had on the defendant. He had no opinion as basically from 1986 to the time of the homicides as to what effect the various filing of documents and appearances, et cetera, had on the defendant. His psychological opinion was based up until the time of their separation. After consulting with Mr. Early overnight, he decided not to testify and give that opinion. Mr. Early chose not to offer that opinion type evidence through any other mental health professional. This court did not exclude any relevant testimony by Dr. Sonkin. It was a tactical decision by the defense not to present that testimony. Therefore, the motion for new trial based on restriction of Dr. Sonskin's testimony is denied. That takes us to the second area of the motion for new trial. There are really 5 different incidents that the defense alleges error from the standpoint of the court restricting testimony as to one or the other of the victim's state of mind. Start first with the Paul Taylor incident. The record is absolutely clear that the defendant had no knowledge of that incident until sometime in November of 1991. Therefore, by no stretch of the imagination could it possibly have affected her state of mind 2 years before at the time of the homicides in November of 1989. Secondly, this was not a self-defense case. Clearly, the defendant was not in any imminent danger of death or great bodily injury at the hand of either victim at the time of the homicides. Since it was not a self-defense case, the reputation of the victim, Dan Broderick, for violence in the community would clearly not be admissible. And so the evidence was clearly not admissible under that theory. I would also note that there was never any evidence even offered by anybody that there was ever any attempt made on Mrs. Broderick's life by anyone at any time. With regard to the Stephen Griffin incident, he was asked to mail an envelope allegedly by Ms. Kolkina in late 1986 or early 1987. First of all, Ms. Kolkina's state of mind was not an issue in my opinion. Secondly, that is excludable under 352, and that any probative value would have been purely speculative, as the offer of proof was that he had no idea what may or may not have been in that envelope. But even if the court were to speculate that there was a wrinkle cream ad in that envelope, and even if I was to stretch legal adequate provocation to include mailing an envelope with a wrinkle cream ad, the 3-year cooling off period between the time that was allegedly mailed and the time of the homicide clearly would not have been adequate provocation for any homicide in November of 1989. It also, in my opinion, is an appropriate sanction under 1054 of the Evidence Code. Since there was a discovery order in this case, it was not used in the first trial because the California Supreme Court had not ruled on the constitutionality of the discovery provisions of Proposition 115. But I clearly told both counsel prior to the start of the second trial, that since the the California Supreme Court in Izaga had ruled that the statute was constitutional, that it would be applied in this case. Therefore, the decision not to immediately turn over that information was in direct violation of my order. And I think there's a proper sanction to exclude it on that basis. With regard to this Tahoe incident of Mr. Smith, again, the defendant herself was not aware of that. And again, it's my ruling that the victim's state of mind at that time was not an issue. But more importantly, in this case, I believe, is the fact that the jurors did in fact hear what actually happened. They had the facts of actually what occurred, many as were over the objection, rather strenuous objection of the district attorney. I let the defense go back as far as 1976 and put in a marriage encounter statement that was written by Mr. Broderick. I let in all of the various filings and hearings that were held in the divorce proceeding, of which there were at least 6 different charts with a timeline, all over the strenuous objection of the district attorney. I allowed Mrs. Broderick wide latitude in testifying and stating exactly what happened to her and exactly how she felt about it. She testified for between direct and cross over a period of 5 days in this case. She had, in my opinion, a full and complete hearing. Although an outsider listening to the arguments of both counsel this morning would think that I kept out every piece of relevant evidence either one of them had to offer. That is not the case. This trial lasted, as those that followed it are aware, for several months. They both, in my opinion, had a full and complete opportunity to present what I found to be relevant evidence. Another basis, or another thing I would note, I should say, with regard to this particular incident, is that what is alleged to have happened is that Mr. Broderick is alleged to have said that he was going to drag his current spouse through the court system. In my opinion, the record of this trial shows that not to be the evidence. In addition to what Ms. Wells has referred to as the testimony of several of her lawyers, And with all due respect to lawyers, I can discount what they said because I know Mrs. Broderick doesn't have much of a regard for lawyers. But if we discount what her lawyer said, we can look to what happened that would suggest strongly that he was not trying to drag her through the court system. We have the fact that a judge of the Superior Court got very upset with Mr. Broderick for arguing that he should not put Mrs. Broderick in jail for contempt. That his arguing to not jail her is certainly not, in my mind, consistent with someone trying to drag somebody through the court system. We have the undisputed testimony that with regard to the alleged improvements, landscaping on the Coral Reef House, that when Mrs. Broderick asked or asserted that in fact devalued the property, Mr. Broderick agreed that the value of those, that the cost of those landscaping items could be taken out of his half of the sale of the proceeds of the house, and that he would give her her half plus the alleged cost of devaluing the property. That, in my opinion, again, is an example of something that's not consistent with somebody trying to drag somebody through the system, but rather is more consistent with somebody trying to bring this thing to a logical and speedy conclusion. I also think the evidence was excludable under 352 because even if there is some relevancy or some remote probative value, that was clearly outweighed by a substantial probability that its admission would have created a substantial danger of confusing the jurors as to the issues and misleading them. The victim's intent, if it was his intent, as expressed after he had been drinking in a cocktail lounge in 1983, was clearly not the issue for this jury to decide. The defendant's state of mind in November of 1989, some 10 months after the final divorce judgment, was what the issue was in this case, in my opinion. Finally, again, this evidence, I believe, is excludable under 1054 as a sanction since the DA, even by their argument today, counsel concedes the DA consistently asked if he had any new information or new witnesses. He chose not to disclose it basically until after the cross-examination of the defendant was finished.
Your Honor, I'm going to have to object to that. For the court to make a finding, I turned that over the very next day. You're talking about Stephen Griffin. You're talking about Steve Smith now. I turned that over at Charles Smith. I turned that over the very next day. For the court to make a finding on that case that it's 1054 at this late date, I think is inappropriate.
You made your record, Mr. Irwin. In my opinion, the whole purpose of the Prop 115 and Section 1054 of the Evidence Code, the whole reason it was passed by the people of the state of California, the whole reason the California Supreme Court upheld it, was to make sure that both sides get a fair trial in a criminal case, just as both sides have had the opportunity to receive a fair trial in a civil case, because in civil law, both sides have had full and complete discovery pre-trial. Up until Prop 115, that had not been the case in a criminal matter. That takes us to the Delta airline incident. There was never any request by me to rule on anything to do with Delta Airlines, period. I never saw any or heard any offer of proof as to anything to do with Delta Airlines. I first read of that incident in quite vivid detail in the moving papers. I had not heard of it, nor had there been any request of me to rule on it prior to today. Finally, the alleged error in excluding the testimony of the local attorney who would have testified had I allowed it that he was consulted by both the victims pre-separation with regard to the possibility of them hiding assets. Assuming that's what he would testify to, that evidence would be irrelevant to a divorce trial. It's clearly not relevant to a homicide trial. Again, I'd note for the record that the defendant had no knowledge of such a conversation taking place. Therefore, it clearly could not have been legally adequate provocation. And finally, I'd note for the record that Mr. Taylor, Mr. Griffin, and the local attorney all knew the parties at least from 1983 forward. None of them chose to come forward during the homicide investigation of 1989. None of them came forward during the first trial, which was substantially and significantly publicized in 1990. They don't come forward till late in the second trial. Over and above and beyond the relevancy issue, that raises a serious credibility question in this court's mind. Therefore, the motion for a new trial is denied. You waive arraignment for judgment and sentence?
Yes.
Any legal cause why judgment and sentence should not be pronounced?
There you go.
Record should reflect that I've read and considered the probation department's report prepared for today's hearing. Record should further reflect that I have read and considered the statement sentencing memorandum or statement mitigation with the attachments filed by Mr. Early on his client's behalf. The record should further reflect that I have read and considered the district attorney's statement of factors for denial of probation. The record should further reflect that I have read and considered the social document entitled Social History with its attachments filed by Mr. Early with this court yesterday. The record should further reflect that I have read and considered numerous letters from friends, relatives, and concerned citizens that were sent directly to the court and which have been filed as part of the court file in this case. Mr. Early.
Your Honor, I believe I was going to report first.
All right. Yes.
I don't think that there could possibly be any disagreement that this case and the events of this case is tremendously tragic in lots of ways and to so many people. It is obviously an absolute tragedy to the family and friends of, for example, Linda Colcana, to Linda's sister and to her brothers and to her father, her father particularly, who has lost his baby daughter and has to live for the rest of his life without her. It is an absolute tragedy to the family and friends of Dan Broderick, to his brothers and sisters who absolutely adored him, to his parents who now in their not too many years left of their life, they have to live with simply the pain of not having Dan with them anymore. It is an absolute tragedy to the 4 Broderick children who lost their father, who they loved and who loved them, and who they deserved to have for their life. It's also a tragedy to the defendant's family, to the Bashalias, who have to live with this and what's happened. There can also be no disagreement that the cause of all of this pain to so many people is the conduct of Elizabeth Broderick. There is no way that this court, by its sentence, can make these people whole again. I know from experience that the pain of losing someone that you love to a violent and senseless death is something that never leaves you. It does get better with time, but it never goes away. And I also know that beyond that, the one thing that makes it truly intolerable to live with is the feeling that justice was never served for that loss. The only way that these people, these victims, can begin to heal is by seeing that there has been some form of justice. I cannot fathom any possible sense of justice when the crimes are murder, when the crimes are taking the lives of 2 people, in any sentence other than one that punishes for both of those killings. To do anything other than that is to say to these families and to these friends that one of the victims' lives didn't matter. One of them was inconsequential. How are we going to say that? Dan's life didn't matter, isn't worthy of punishment. Linda's life isn't worthy of it. It is also to say to not only this defendant, but to everyone else out there, that if you're going to kill someone, you might as well go ahead and take out a couple extra people too, because as long as you do it all at the same time, those killings are going to be free. Elizabeth Broderick has been convicted of intentionally shooting and killing without provocation 2 people who were in the most vulnerable position they could possibly have been in their own home, in their own bed, sound asleep. The concept of not punishing her for maliciously taking each of these lives, to me, is abhorrent. And it certainly doesn't smack of justice. Defendant discusses in his sentencing statement the sentencing rules, particularly Rule 425, regarding consecutive sentences. And as the court knows, those rules do not apply to indeterminate terms. But even if you wanted to use them as guidelines, the defendant's argument regarding consecutive sentences for separate acts of violence is flat out wrong. The argument is just simply wrong. And even the case that they cite, People versus Thurs, states what has long been the law, as long as I know, that a defendant can be punished for each crime of violence against a separate victim, even if the defendant entertains a single objective, which she obviously didn't hear. She wanted to kill both. And even if it occurred during a single course of conduct. Even, in fact, the case law is if she had shot one bullet and it had gone through two people. The law says that the court can appropriately give consecutive sentences. How can killing two people not be more egregious than killing one? The defendant also suggests that concurrent sentences should be imposed because this was simply a single period of aberrant behavior. Well, that simply ignores the facts. The defendant had been violently acting out on her anger against these victims for years. But what she really is all about underneath, and underneath, she is a very disturbed woman. One of the issues with respect to the defendant is her potential for future violence. The defendant argues that the circumstances leading to her committing these two acts of murder will never repeat. Therefore, we shouldn't worry about it. I very strongly, adamantly disagree with that. Obviously, the exact same circumstances are not going to repeat. But the circumstance of Elizabeth Broderick feeling that she has been wronged by someone is absolutely likely to repeat. In fact, it has repeated. I know the court is aware of the letter that Elizabeth Broderick only recently sent to Kathy Broderick. It was attached to Kathy Broderick's letter that was sent to the court. And I'd like to just read a small portion of that letter. She's writing this letter to her son, Danny. Why is Kathy Broderick being such a bitch about letting you kids be with me? I never thought she'd be such a jerk. She knows well how bastardly Broderick men could be. I would have expected her to have more sympathy. Too bad she's causing us all more trouble. It didn't have to be this way. February 4th is the next hearing on custody. I will be strongly opposed to her having anything further to do with our family. She is not in our family, I am. If she keeps me from communicating with you, she's gone. None of us need any more of this shit. Kathy Broderick, by the way, as the court I think knows, is the aunt of the Broderick children by marriage. And immediately after their father was brutally killed and their mother was placed into custody and they were essentially orphaned, Kathy Broderick had the compassion to come forward and take these children into her home and give them love and give them security, in particular, the two boys. She has 3 young children of her own to raise. For over 2 years, she's been taking care of these boys under very difficult circumstances. And what does she get for that? Not thanks for being there for them. She gets hate and anger and threats. Do we really want to take the chance of taking these threats lightly, like people took the threats that she made against Dan and Linda lightly? And maybe even more important about what's going on in this letter is what she is continuing to do to her children that she did all along. And this is something that frankly never ceases to amaze me. Danny, her son, is living in this environment, living with his Aunt Kathy. Does it occur to Elizabeth Broderick to tell Danny, to assure him that Kathy loves him, cares about him, to encourage him to love Kathy back, to foster a good relationship between them so that he can be happy and secure? No. What she does is spew hate at the expense of her children. No matter how you want to analyze this woman, whether you want to say she's evil or whether you want to say she's sick or she's psychologically troubled, the fact of the matter is that Elizabeth Broderick is one of the most supremely selfish persons that you can possibly conjure up. And the way she has treated her children epitomizes that and continues to treat her children. She thinks she's special. Her jail jacket is amazing. She thinks she deserves special treatment. The fact of the matter is, she is simply a textbook narcissist. She is a narcissist who is so absorbed in her own self-importance that she emotionally abuses her children, sacrifices them, that she kills because she's angry, that she acts out violently in the jail, including doing things such as smearing excrement on the walls because something didn't go the way she wanted. That's the essence of Elizabeth Broderick. And she's never to blame. She's always the victim. Well, Elizabeth Broderick is not the victim here. If anything, she's the victim of her own inability to truly care about anyone other than herself. And that's not something that just suddenly appears in a woman when she's 38 years old. I think that it's time for everyone, including the press, to do what Elizabeth Broderick so richly deserves, and that is to ignore her. To her, that is a fate worse than imprisonment, because she so loves and so well plays the part of the martyr. Well, Elizabeth Broderick is not a martyr. She's a murderer. She's a convicted murderer. And it's time for her to be treated just like every other convicted murderer. And that's by imposing sentences for each of the murders that she committed. There are some people here in the court that would like to address the court, Your Honor. And I think it's appropriate to do that at this time before the defense speaks.
Certainly, go ahead.
First of all,
Hey.
no, she's got to pay. Mary's back, Your Honor.
Go ahead. State your,
I'm sorry, go ahead.
state your name and spell your last name, please, ma'am.
My name is Margaret Kolkena Seats, Kolkena -Seats, Seats.
Thank you, ma'am. Go ahead.
Thank you, Your Honor. And I think that the only pictures you've probably seen of Linda have been of her body, so I'd like to just put this up there. These past few weeks, as I tried to prepare for today, I had difficulty framing my thoughts. How can I possibly summarize the impact that Linda's murder has had on our family and on our friends who loved her? Earlier this week, I spoke with Carrie Wells, who reminded me that the only things you know about Linda are what came out in the trial, which is not complete. So what I would like to do is tell you about Linda and the kind of family we come from. Our parents grew up in a small town in Holland called Groningen. They both came from big Catholic families, and a large part of their childhood was spent under German occupation during World War II. After our father served a stint in the Dutch army stationed in Indonesia, Mom and Dad met through Mom's older brother, who was a friend of Dad's. Our mother came to the United States with her family in 1954, and then traveled back to Holland 1.5 years later to marry our father. They were married by a justice of the peace in Holland, but did not share a cabin on the trip back to America, nor did they live together until they were married by a priest and in the eyes of God. 3 days after coming to Salt Lake City, which is where we all grew up, Daddy started working at Garrett Freight Lines on the loading dock. Often he would work a second and sometimes a third job to support our family, but he would remain at Garrett throughout his work life, 37 years. I am telling you all of this because I want to give you a sense of the strong values with which we were raised. We grew up in a traditional old world family which took with a strong work ethic and a sense of what was important in life. We did not have a lot in material goods, but we were well loved and each one of us knew that our parents loved us very, very much. Our mom was wonderful. She was extremely bright and created a stimulating environment at home. She was a den mother for our brothers and was active in the church and the school. She embraced life and was one of the most optimistic people I have ever known. I remember her smile and the upward tilt of her chin whenever she watched one of us at a dance recital or a PAC meeting. Daddy didn't particularly like sports or outside activities. We were his leisure, and I can remember him saying how much he liked his job because he could leave it at the end of the day. His focus was on us. He especially liked geography, and I remember evenings after dinner sitting at the table, all of us testing one another on countries and their capitals. It sounds too good to be true, but it was true, and we were a very happy family. Then, when she was about my age, our mother was diagnosed with breast cancer and had radical surgery. She was in remission for several years, but the cancer returned, and she was sick for a long time. But even through the radiation and the chemotherapy, she managed to worry about us and take care of us. I remember her weaving a wreath of flowers for me to wear to my junior prom. At age 39, she died, leaving 4 children, ages 11 to 17, behind. I can still describe what a sad time that was for all of us. 18 years later, we still miss her loving presence in our lives. Linda was 5 years younger than me, and for a time I tried to step into my mother's role. Linda and our brother Ray, who is here today from Germany, were very close at this time. We clung to one another because after losing Mom, we knew how precious family is. Poor Linda was the youngest, and her 12th birthday was just 2 weeks after Mom's funeral. Mom, who had always made such a fuss over special days, wasn't there, and Linda's birthday was forgotten that year. When I went away to college the following year, Linda told me later how abandoned she felt. She started working as soon as she could because, like all of us, she had that strong work ethic. Linda was a fabulous babysitter, and in Salt Lake City, there were lots of opportunities. The families on our block liked to have Linda watch their kids. Linda loved one family in particular. They had 7 kids, and Linda went over almost daily to help Joanne, especially with the twin baby girls. Linda had a knack with babies, and many of us can tell you how she loved to hold any baby in sight. She loved children. She was so happy when our son Matthew was born and came to visit us while he was still an infant. She was a delightful, fun-loving aunt and often sent little things to the kids, such as pencils with their names printed on. They were simple things, but evidence that she thought of them often. Both of my brothers can also tell you what a wonderful aunt she was to their children. Obviously, Linda was beautiful. We happen to have come from very handsome parents, but that is not why people were drawn to her. She had that same joy in life that our mother had, and people, both men and women, wanted to be around her because she was such fun. I never laughed more than I did when I was with Linda. Her friendships were based on the same values with which she was raised. It is dismaying to those of us who knew her well that Linda has emerged as some kind of gold-digging bimbo. She was very quick and intelligent, and anyone who knew Dan knew that he had a low tolerance for ineptitude, and she would never have continued as his legal assistant if she had been stupid. Linda was unusually cautious in forming romantic relationships. I believe that she could have become involved with several men equal to Dan in stature, but never did. When she confided her relationship with Dan to me, I knew that it was important. Another relationship would have been so much easier, but Linda truly loved Dan, despite all the problems he would face. It was a testament to her deep and abiding love that she hung in there with him through all the harassment and obsessive haranguing by Betty. As Betty's actions became more than just an irritant, as they became increasingly violent, we grew concerned for Linda. But she loved Dan, and Dan, unaccustomed as he was to a loving partner, loved her very much. I remember so many calls of frustration from Linda when Betty had left yet another obscene message or worse, and I questioned Linda's wisdom in staying with Dan. For my part, I could not have tolerated that litany of abuse. With each passing year, As we became adults, Linda and I grew closer than ever. She was my dearest friend and my greatest champion. She celebrated my successes and was a rock in times of trouble. I feel very lucky to have had such a loving sister. To help you understand her warmth, I'd like to play a tape of a message that she left on my answering machine.
The recorder doesn't have to take down the tape.
Yes, Your Honor.
Yes, Ron. Go ahead.
Hi, Margaret Mary, it's your sister. I was cleaning out my closet this morning and I came across the letter that you gave me on my wedding day. I just wanted you to know I found it. And I just read it. It makes me cry because it's so nice. I hope you had a good time in LA. And I will talk to you next week, I'm sure. See you, bye. Love you.
Linda left that message for me on Saturday, November 4th, 1989. Less than 24 hours later, she was dead, killed with 2 well-placed bullets, first to her chest, and then, as she lay dying, another to the base of her skull. And now, at long last, what we all knew is now a matter of public record. Betty Broderick was not justified in deliberately killing my sister and Dan. She did, in fact, murder them. And on Sunday, November 5th, 1989, while I was in Los Angeles doing some work, my husband called me and said, "Margaret, your sister is dead." He has since expressed regret over the bluntness of his news, but no words, no matter how well chosen, could have softened the impact of those words. Linda, our dear, happy Linda, was dead. This is called an impact statement, so I will try to describe the impact that Linda's murder has had on us. That first numb week as I worked with Dan's brothers, Larry and Dennis, to put together a double funeral, the initial phone calls from the media began. One by one, family members arrived in San Diego. Whereas we had gathered 6 months earlier to celebrate a wedding, we now quietly gathered to cry and mourn. I returned home to my home in Portland, Oregon, where my shocked children tried to cope with the news that their beloved Aunt Linda had been shot. For months, Matthew had nightmares of an intruder breaking into the house during the night and shooting us in our beds. Just 2 months ago, when 2020 did a program on this, we chose not to watch the show. But 2 evenings prior to the airing, they showed a commercial advertising it. Until that time, we had successfully avoided any pictures of Linda dead, but there, suddenly on the television screen, was a picture of my sister's body, and I watched the blood drain from my 11-year-old son's face as he saw it. Our little Elizabeth had a delayed reaction weeks later, finally letting her grief out when it was triggered by a photograph. My brother Ray and Roger, who was stationed in the Air Force in Turkey, struggled with their loss. All the more painful because they had not seen Linda for several years and had not had the money to attend their Linda and Dan's wedding. And our poor daddy. He and our stepmom of 16 years miss Linda so very much. He does not have the emotional fortitude to be here today. He told me, "Oh, Margaret, I can't be there." He simply could not be in the same room as the murderer of his youngest child. And I know what he means. Until today, I had not seen the murderer before. Daddy doesn't get his Monday night phone calls from Linda, who was in frequent contact with him. He doted on her, and she adored him. At their funeral, Mike Reedy and his musical partners sang "Make Me a Channel of Your Peace" at the funeral mass. Daddy cannot listen to that song or Danny Boy without crying. Daddy lost his wife 18 years ago, and his daughter, who was only 28. I pray often that nothing else bad will happen to our family. The impact of the media has been substantial. The murderer, who hired a public relations firm early on, and her attorney have been very aggressive in courting the media. Our families have tried to avoid the media, but have been compelled to talk to them. The defense strategy has been to paint Linda and Dan as villains, and we are put in the position of defending their right to be alive. They are the ones who were murdered. They have been put on trial. I am baffled by it. Linda and Dan were murdered. They should still be alive. But they can't speak for themselves anymore, so we must try. I only want the media to know how painful it is for us to have our tragedy turned into primetime entertainment in the Sunday night movie. We are not characters in a bestseller novel. Linda and Dan were real people, and we are real people. For my part, I miss Linda in 1,000 ways. I miss laughing on the phone with her. I miss singing to the talking heads at the top of our lungs as we go down the freeway. I miss celebrating successes such as my degree and my new dream job with her. And I really need her when I am down and need a shoulder to cry on. I wanted to grow old with Linda. I wanted to be an aunt to her children. I wanted to spend a lot more time with her. But she's dead. And when the pain of her death is especially strong, I hold her white cotton nightgown to my cheek and rock and cry bitter tears. She was only 28 years old, and for the rest of our lives, we will be without her. No sentence could ever be in proportion with what was taken from Linda and what we have lost. Thank you, Your Honor.
Thank you.
Terry Broderick would like to speak at this point.
Good morning, sir.
Hello, Your
You'd
Honor.
state your name and spell your last name,
My
please.
name's Terry Broderick, Broderick.
Yes, sir, go ahead.
I'm speaking here on behalf of my brothers and sisters and of my mother and father who can't be here today, and on behalf of Dan and Linda. Dan was my eldest brother, the eldest of 9 children. He had 4 brothers and 4 sisters. All the boys, including Dan and my father, went to Notre Dame, and all my sisters, 2 of which went to St. Mary's, and the other 2 went to 2 other universities. But they say that a picture is worth 1,000 words, and we've had this picture in our family for the past probably 40 years. And if I could present it to the picture is basically a picture of a child on his first day of school, and that's my brother Dan, and it was his first day of school at St. Bernard's. And as you can see, the principal of the school and none is overlooking him, and he's looking up to her with, I think, a trusting look and not knowing what's ahead of him. And that picture to me is also symbolic of what you have before you today. And as much as Dan in that picture represents the innocent people in society in general. I have some notes that I wanted to go over. As far as my parents are concerned, when they think of Dan and the loss of Dan, they do not think of a fellow that was 44 years old. They think of a child that they place into this world and who grew up, and they tried to instill the right values in him. And as it is said, it is a long and hard and painful to create life, and it is short and easy to steal the life others have made. And I would hope that the court will show us that the lives that they had did not go in vain and did have some value. Once again, my parents grew Dan as a child into an adult person, and I believe Dan, through the course of his journey, chose to do the right things in life as opposed to the wrong things. He had options in front of him, and some would have been easier. Some of the things would have been easier to deal with Betty in her times of trouble, but he tried to do the things the right way, the things that I think all of us would hope to do in our journeys. And so my question when I look at that picture is where did he go wrong? What did he do wrong to get the rewards that he and Linda both received through Betty's actions? And I looking at the whole thing, wonder what did she do right where she would have some type of reward that would be less than the maximum penalty in front of them. What's the point in doing right and doing wrong for anybody that is in a state of crisis and has decisions to make if they cannot look to the system of justice for the right answers? And once again, that picture to me is the same as people looking to the system for answers, some type of direct. if justice does not act as the counterbalance to those who do us wrong, then what is the point to all this? There's no path of destruction in Dan's wake and his actions in life, and he has no reward to show from it other than his good friends. I think that when all is said and done, I think the media has basically dragged his name through the mud in exchange for a good story, something to sell more newspapers. And if I look around and I say, what was the point of all his achievements and everything that he's reached for in life? I think the evidence that I see before me is his loved ones and his friends. And those are evidence enough of me, of the type of person Dan was. And I appreciate them. What kind of message are you going to send to those out there in a state of crisis? Those that choose to do right, those that end up with taking the evil, selfish, destructive side. I received a letter yesterday from a person that I'm not going to mention, never heard of this person before. She said, she tells me her name, and she says that I'm in a similar situation to Dan and Linda, and I would be like Linda is. I am married to a fellow who had been married once before, and basically have been subjected to everything that Dan and Linda has been subjected to except murder. And she says, and she does not see that to be something that wouldn't happen also down the road. And she actually writes this letter and asks me, what is she supposed to do? How does she handle it? What does she take the law into her own hands like some would have thought Dan should do? And in which case, Betty might have ended up in the hospital 2 or 3 times. Dan would have been in jail. And a lot of people in America would have done that. They wouldn't have chosen to do the right thing and to put their faith in the judicial system. In terms of people being divorced each year, there are thousands and thousands and thousands of people that are divorced. Probably at least 50,000 in California each year get divorced. And if an example is set up where a person is rewarded by giving some consideration and leniency in their punishment, how are these people going to look for that in terms of a solution to their own problems? On the behalf of our family, we believe that less than the maximum sentence, and I don't know exactly what that is. I believe it's life in prison without parole for each of the murders is a victory for the convicted. To Betty Broderick, who shows no remorse and acknowledges no wrongdoing and responsibility. To her, Dan and Linda were worthless trash who got what they deserved. And anything less than life without parole rewards her and is a token of acknowledgement of her so-called victimization and lends a degree of credibility and justification to her heinous crimes. Anything less than life in prison for each of the victims, Dan and Linda, implies in some way that they are less than innocent and therefore are entitled to less than most of us would expect for ourselves. If this was a state such as Texas or such as Florida, she would probably be going to the gas chamber or the electric chair. But this has been a series of compromises from my perspective. At no fault of the DA's, I believe that the first compromise was the fact that she could have been charged with first-degree murder with special circumstances, which brings with it a capital offense, and which can be death. The second compromise, I feel, was a compromise by the jury, and I applaud the jury for coming up with a conviction, but it was a compromise to get a conviction. And now the possibility of her walking away from these crimes at some point in the future, I believe, would be devastating. Please do not further compromise the standards of the justice we have grown to count on and expect, which mandates the nature of our own actions. Do not reward her with a less than maximum sentence by giving her something to look forward to and punishing our families, in a sense, with the constant knowledge of her temporary incarceration, and will walk away free someday. End this for all of us. It will be a great blow to the memories of Dan and Linda and all that is right and good in this world to let her go away from her crimes. Send a message to those treading similar waters and restore dignity to Dan and Linda's names and to all those that work hard to stay true and straight. Please put an end to this for all of us. The triumph of justice is our only peace. Thank you.
Thank you, Mr. Broderick.
Mr. Monahan also has a few words for the board.
All right.
About 2 years ago,
State your name, spell your last name for the record, please.
Brian Monahan, Monahan. At the funeral of Dan and Linda, Larry Broderick at the last minute asked me to speak on his behalf. I'm doing that in a sense today, but also for people like Ray Kolkina, and his wife Ava, who came all the way from Germany, staying in my house. For the 17 people who went to Ireland this year to dedicate a church to Dan and Linda and put some of their ashes in the ground of Ireland. For clients of Dan's who came to me after his death, for friends like Mike Neal, Vince Barlotta, Mike Reedy, for a lot of the people that were affected. I guess I probably should explain what my basis for this is. My experience with Dan, with Betty, with Linda goes back a number of years. I met Dan when he was still at Harvard Law School. He interviewed out here in 1973 or 74. We practiced at rival law firms. We tried at least one case against each other. We became the best of friends. We met at least weekly. I served as his attorney occasionally. He served as my attorney. I was his vice president, or one of his vice presidents, when he was president of the Bar Association. I shared at his house probably the last Thanksgiving the family had together. I shared with my family and his family probably the last ski trip, Christmas ski trip that they had together. I met Linda when she first came to San Diego. I knew her very well. She was a very close friend of mine. That's the background. I think there have been horrible distortions put before this court in the two trials. One of the distortions is that this was a happy marriage. It was never a happy marriage. Those of us who saw it knew it wasn't a happy marriage. Dan cried 2 weeks after the wedding on a bus in New York City, in the back of a bus, cried because he knew that he was into something that was horrible. He made a terrible and tragic mistake. Betty drove that marriage into the ground for years and years and years. The second thing that I think is intolerable is to paint her, as she's done so well, as the victim. She made choices. At the time of the divorce, Betty was not the person you see sitting in this courtroom. She was a beautiful woman. She was intelligent. She was rich. She had a home in La Jolla, $16,000 a month. She had a lot that she could have done with her life. She had a wonderful future ahead of her. She had friends like Helen Picard, Gail Forbes, who urged her to get on with her life, but she chose. She made a conscious decision not to get on with her life. She chose to spew hate on Dan. She chose to use her children as weapons. On the morning of the murder, when she stood in that bedroom, having already shot Linda, looking down at the father of her children, gurgling in his own blood, with one bullet left in her gun, she chose to step across the room and plant that last bullet in the back of Linda's head. That was her choice. Having killed him, she chose to take away the last thing that they had, their names. And for the last 2 years, she has done nothing but tear down their good names. None of us can repair that. She chose to take this the slime story to the tabloids, to take it to the supermarkets of America. One story said, "Why did Betty wait so long to kill her husband?" That was the title on the front of the magazine. She pandered to those. And during that whole time, there was not one hint, not one suggestion of remorse. The picture of Betty Broderick at the reading of the verdict is a picture that tells as much as that picture that you have before you of Dan on the first day of of school, and that is a smirk on her face. She beat the system. She got away with second-degree murder. I'll never forget that smirk. It reminds me of the statement that she made to the bailiff, that she had the jury eating out of the palm of her hand. She's a woman without a drop of remorse to this day. She remains a threat. I described her quite accurately to one of these media people. The next day I got a call threatening my life from somebody. She's threatened her daughter recently, Kim. She's a threat. She has made choices. She made the choice to go to the tabloids with this. She's got to suffer the consequences of that. She's responsible for the choices that she made. All these people out there in this country, deterrence is one of the things that the court has got to consider. All these people have read her side of the story, and they're now waiting in supermarkets all over this country to find out what sort of justice we dispense here in San Diego. What the people of San Diego feel about these acts. It's in your hands.
Thank you, Mr. Monahan. Anything further, Ms. Wells? Mr. Ehrlich?
Your Honor, sentencing in this court is in an open courtroom, and the court has considered, for the main part in this case, evidence that has been adduced in an open courtroom. That is not the history of this case. It is not the history of the case. It is not the present of this case. It's not the future of this case. I've been shocked when I have read in the district attorney's discovery and our discovery with witnesses that there was a divorce in this county that stretched over 5 years, that there was a move by Mr. Broderick and his attorneys to have all those hearings closed, which means that they know that the purpose of having it closed is so that nobody knows what's going on, one side or the other. But Mr. Broderick must have decided that my story will get out about the bad things about Elizabeth Broderick, because he talked about what went on in those courtrooms. He talked about the problems he was having, even though he asked those hearings to be closed, even though he asked that information not to get out. The reason that I bring it up is the district attorney argued a statement from Kathy Broderick, and she argued a letter from Kathy Broderick. And Kathy Broderick asked for a closed hearing, and she's been hiding behind those closed hearings. A court in San Diego will never find Kathy Broderick in contempt, will never bring forward that she asked for a closed hearing. But when she thinks it suits her, she'll bring out what information she wants. I don't want this court sentencing Elizabeth Broderick because they say that she has no compassion for Kathy Broderick because she has the children of Elizabeth Broderick. The district attorney read a letter. The district attorney did not choose to write the letter that Elizabeth Broderick got in the middle of the trial from her child that was burned at the bottom, that said he wanted to kill himself because he could not stand to live in Kathy Broderick's home for once more. She did not decide to bring forth a letter that for 1 year after she was incarcerated and those children were whisked for Colorado, she wasn't even able to send a card to her children that say happy birthday, Merry Christmas. Not even a card was she allowed to send to her children. She did not bring forward that the compassion from Kathy Broderick has not been that she's kept 2 children, but that she has charged her estate $75,000 to $95,000 for their support so that she can support her family. When she brought up Larry Broderick, I would like the court to include as a letter Larry Broderick's statement about the children. I would be inclined to play the tapes and have the boys testify as late in the trial as possible, so as to have the greatest possible lasting impact on the jury. She didn't care, he didn't care about the children. They looked at them as pawns in a game. Those children, Kathy Broderick, who has been there, when Kathy Broderick had those children, Elizabeth Broderick said, if that's where my children want to be, and if she is a good mother to them, that's where they should stay. And then the children complained about being there and said they don't want to be there. And they have other family members, and it's not a blood relative. It's against it's in the opposite of what the code says to look for. And members of her family that were willing to have the children at no cost to them. They remained in Kathy Broderick's home, even though she was going through a divorce. Even though in that hearing, when those kids had over $400,000 stolen by Larry Broderick, they said, don't sue Larry Broderick for their money back because it might affect Kathy Broderick in her home. So the boys should give it up so that Kathy Broderick doesn't have a problem with that. And in the hearing, when it was recommended by the county that she be not made permanent guardian because of problems with the children, because of conflicts of interest, because billings that have been called into question in the probate court by both the attorneys that represent them, that have a conflict of interest, that represent Larry Broderick, that represent Kathy Broderick, that at the time that they're representing him have a relationship, an intimate relationship with Kathy Broderick. Those are things that don't come out in the public. Those are things that they decide shall be brought forward the way they want them to be brought forward. But none of those things are true, and those hearings remain closed. And then the court is told you need that this is all done for the protection of the children. What the court is told is what they want the court to be told. If they want the hearings open, if they want to give information, they should bring that information forward. That letter was about a hearing where the boys were saying, I don't want to live with Kathy Broderick. My cousins hate us. They fight us all the time. They scream at us. We feel unwanted. If we mention our mother's name in the household, we get in trouble at all. We want to talk to our mother. We want to visit our mother. She is our mother. And we don't want the estate to spend thousands of dollars of our money fighting our wishes. And so when she went to a hearing, Elizabeth Broderick's position was, Kathy Broderick should be gone from being the guardian of the estate if that's your desires. And that's what the recommendation is. Why should you have to be there at that point in time? But the court is only told one part of the letter. The court is told that Elizabeth Broderick hired a media consultant. Elizabeth Broderick never hired a media consultant. She had a lawyer at one point in time that looked at it, never with her consent, did not keep the lawyer that decided to do that. But they talk about her being in the media, and that's the only thing that she wants to do is get into the media and ruin these people's good name. What was interesting at every hearing that we had in this case, there was a planned, orchestrated event around Dan Broderick. It's interesting, in a Dan Broderick room, there's a plaque of all the lawyers, and there's a portrait of Dan Broderick, as if the lawyers donated it all. No one told them that they charged that to the estate, that the boys ended up paying for that they didn't know, and the public never knows that. They don't know it at all because it's a media event. When they go forward at the time of the preliminary hearing, and they had a memorial, when they had a time that the planning of a dedication of a church was at a time when the trial was about to start in Ireland. And I don't even have to remind the court of the number of statements about Mr. Broderick's belief of the Catholic Church and his estrangement and not wanting and not believing in it, and the statements that he made in his marriage encounter about it. Yes, there are times when there are two sides of the story. And what's been portrayed is that the defense and that the media are reporting the other side as well as the side that wanted to be believed by half the people. I think that the court should consider both sides. I think that the court should look at the history of this case. And I agree with everybody who has come forward. I believe that this is a tragic case. I believe that there has not been 2 victims. There has not been 6 victims, including the Broderick's children. There's been the Biseglia family. There's been Elizabeth Broderick. They are all victims, and they are victims of the things that happened in this case from the beginning to the end. Whether you want to believe how they came about, who caused them, but what you had in Elizabeth Broderick is a woman whose life was decimated, and it was decimated. And she suffered at that time, and she committed acts that she should be punished for. It has never been our position that she has done nothing wrong at all. And I don't think it's the court's position to look at the sentencing that the court is looking to melt out in this case and to say that there won't be any punishment in this case. Whether the court picks concurrent or consecutive sentencing, the punishment in this case will be great. If the court is to pick a concurrent sentence, under the present parole guidelines, the earliest that she would ever get out with just 1, not even, and that's if the court just stayed 1, would be 20 years of actual service. And that means that she would get out at the age of 65, would be the very earliest that she would get out. I am asking the court to consider, and the reason that I put in the guidelines asking for concurrent time is so that the court can consider that at some point in her life, at some point after serving at least 20 years, that she would have some ability to die outside of prison. Probably the hardest thing that this court is going to do is look at this case and saying, we are not sentencing Elizabeth Broderick because she killed somebody who was in the system. It's disturbing to see that in the newspapers, there's comments from the legal community that don't even suggest it as the court. They're confident that Tom will do the right thing. They're confident as to what the verdict would be. And that's without hearing any, hoping that would happen without hearing any evidence in this case, without having the court consider anything in aggravation, in mitigation, and whether the sentence should be concurrent, whether the sentence should be consecutive. It's going to be very difficult. The court has nothing to gain, at least among the legal community, to look and view this case any different, to say whether the court should give it a concurrent sentence. And I just think it's impossible for the court to look in this case and say, what would have been the outcome of this case if we would have had someone who was not in the legal system? If we had someone who was a plumber or a newspaper writer or a banker, because you just cannot remove that. But I would ask the court, when you look at the incident itself, when you look at what she was going through, I can't see how the court can say that this was not something that was part of just very large emotions. Everyone has asked the court just to ignore the jury verdicts. I think that if the court is to look at the jury verdicts, if the court is to say that we are a system that has a jury system and we follow the decisions that were made by the jury in this case, there's only 2 theories, and I brought it out, that the jury had to look at provocation. Maybe they didn't agree it was sufficient enough to say that it was a manslaughter. But the only way they could have reached a verdict of second-degree murder was either under a theory of implied malice or under a theory that there was provocation that brought these acts about. They took place in a very short period of time. The court, by giving concurrent sentence, is not sending any message out that people will not be punished. Elizabeth Broderick will probably spend virtually all of her life in state prison. The only thing that we are asking this court to do is to consider of whether she should have some opportunity at some point in time to contribute something. No argument that she shouldn't pay. She will pay for a very, 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 very long period of time. I'm asking the court to consider the fact when you see all of Elizabeth Broderick's friends who have come forward, people in the neighborhood that knew her, her neighbors, her friends, the mothers, the woman who saw her on her day-to-day life, describe somebody completely different than what happened to her in 1983, 1984, 1985, and the period that followed. I think the court, when it looks at the deterioration, the absolute physical manifestations of what she was going through and the things that brought her here today, can see that she is a victim, as well as her family, as well as Dan Broderick, as well as Linda Broderick, as well as the 4 children, and all 4 children. Even though Kathy Broderick mentions that they had 4 children that were victims, the only one she mentions in her letter, she leaves Lee out. And that's because Lee was at least somewhat understanding of her mother, understood what she was going through, understood that the pain she was feeling. And what I'm asking the court to do is to also consider that, and consider the fact that she has been a contributing member of society. She has done very well for society in the past. And I believe after that period of time in incarceration, after going before a review by a parole board that will be looking at all of the issues presented by these people, all I'm asking for the court is that she have some opportunity, given her age, her position, to at least be able to come out and die outside of state prison. And I would ask the court to look at the evidence, and I would ask the court to make the determination on the jury verdict, on the evidence that was presented and what the court saw. And I would ask the court to resist, and I can't say it any other way, to resist the temptation of looking to say, am I a hero in the legal community if I give her consecutive time? And am I looked upon, down upon in the legal community if I give her concurrent time? And I would ask you to base it on the facts of the case and on the totality of the circumstance that you have before you.
Thank you, Mr. Early. Mr. Probation Officer, anything further from probation?
Nothing further from probation.
You're Mr. Gaughn. G-A-U-G-H-A-N?
E-N.
A-N, just for the record. All right.
Thank you.
Submitted?
Yes, Your Honor.
Submitted, Mr. Early?
Yes, sir.
Well, let me start by saying that although there's been heated advocacy on both sides, I want to compliment all counsel for what I think was a very vigorous and competent job of presenting their respective positions. Others may second guess you, but having sat through 2 trials and lots of motions in this matter, I think you both did excellent jobs representing your respective parties. As you have both touched upon, this case has been a tragedy from start to finish. It's been a tragedy for the friends and relatives of Daniel Broderick. It's been a tragedy for the friends and relatives of Linda Colquina Broderick. It's been a tragedy for the friends and relatives of Elizabeth Broderick. But probably most significantly, it's been a tragedy on the 4 Broderick children who are basically orphaned. There is nothing I can do that can change any of that. I would also like to mention, for the benefit of those in you in the audience, that there was one common thread that ran through all the letters I received, no matter who sent them to me, no matter whose side they were, say, advocating one way or the other. That common thread was that no one thinks that this should go unpunished. Everybody believes that her conduct deserves punishment. There was one other common thread that I would like to comment on, and that is the amount of strong emotions that were evidenced in the letters by representatives for both sides. Those emotions are certainly understandable to me, but I think, and I would like to suggest to all of you, that now is the time to set aside those emotions and start a healing process. These events have gone on long enough. They've been going on for over 2 years in my courtroom. It's time to set them aside and to start some kind of a healing process. And one final comment before we get to the actual sentencing. This is something that the lawyers are certainly aware of, but maybe you aren't, you being the members of the public. I never met Dan Broderick. I never met Linda Broderick. I never met Elizabeth Broderick. I state that to you so that you can understand that I have no personal interest in this case one way or the other, and the fact that both lawyers were upset with my rulings during the course of the trial may be the best evidence that I did my best to take no sides in this trial. I tried to give them both a complete, fair, and open trial. And somebody later on will decide whether or not I was successful in that. But I want you to know that I had no personal interest in this case. No one from the legal community has pressured me to do anything in this case other than what I think is right. I've had no contact, direct or indirect, by anybody in the legal community regarding what I should do today. My sentencing decision in this case is based solely on the evidence that I heard during the course of the trial and solely upon the laws of the state of California. In this matter, probation will be denied for the following reason. Pursuant to Penal Code Section 1203.06, the defendant is statutorily ineligible for a grant of probation in that she has been found guilty of personally using a firearm during the commission of the crime of murder. For the crime of murder is charged in the second degree as charged in count one, as found in count one by the jury. The term for that is 15 years to life in the Department of Corrections for their finding that she personally used a firearm pursuant to 12022.5 of the Penal Code. The term is 2 years consecutive by law to the term for the underlying offense. So for count one, she's sentenced to the Department of Corrections for a term of 17 years to life. Since murder is a crime that carries an indeterminate term, as both counsel have mentioned, it is not necessary for me to state sentencing rules for determining whether or not I should impose a consecutive or a concurrent sentence. However, to avoid any and remove any speculation as to my reasons, I intend to state reasons for imposing a consecutive sentence. First, these were separate acts of violence. The physical evidence, which is uncontradicted, shows that she intentionally and deliberately aimed at both people. Physical evidence would show that at least one of the shots, regardless of what order they were fired in, was fired into the mattress through Linda's body. The physical evidence shows that at some point she fired shots at almost a 90-degree angle towards the other side of the bed, some of those bullets going through the wall and ending in the hallway. The physical evidence uncontradicted that she intentionally aimed and shot at both people. Secondly, the evidence is also abundantly clear that at the time she left the bedroom, Linda Colpina Broderick was dead and Dan Broderick was not. Therefore, it's not just the pulling of the phone from the wall, but in my opinion, it's the carrying the telephone into the hallway and discarding it there that evidences a high degree of callousness on her part and further justifies a consecutive sentence. And last but not least, the jury found that she intentionally killed two people. Therefore, the crime of second-degree murder in count two, I select the term of 15 years to life, consecutive to that opposed in count one. For the enhancement of pursuant to 12022.5 of the Penal Code, the 2 years for that is stayed pursuant to the California Supreme Court decision in In re Calbrith. It's entitled credits in this case for time served of 824 days actually served, 412 days good conduct credits for a total of 1,236 days credits. Further order, she pay a restitution fine pursuant to Government Code Section 13967 in the amount of $500. That fine to be paid forthwith or is provided for in Section 2085.5 of the Penal Code. Statutory law, Mrs. Broderick, allows you to reduce the sentence I've imposed upon you by up to 1/3 by your earning good conduct credits. The amount of credits to which you will be entitled will be determined by the Department of Corrections. You have appellate rights in this matter. You have the right to appeal from this judgment. If you wish to appeal, you must file a written notice of appeal with the clerk of this court within 60 days from today's date. If you do appeal and are unable to hire a lawyer, the appellate court will appoint a lawyer to represent you on appeal free of charge. You will also have a right to a free transcript and record of the necessary parts of this proceedings that were held in this court. The written notice of appeal must be timely filed. Do you have any questions about your rights to appeal, ma'am?
No.
Do you understand your appellate rights?
Yes.
All right. That's the order. Thank you. We're in recess. Oh, excuse me.
I have one other additional request. Even though the California Institute for Women at Frontier is probably the most high-level institution, it does offer some psychological counseling, and the court cannot order her placement, but I would request that the court at least recommend that they consider her placement at the California Institute for Women at Frontier.
All right. I'll have the prison packet show the court recommends she be housed at Fonterra. We're in recess. Thank you.
Eric and Lyle Menendez, the infamous brothers, the savagery of their crime, the murders of both their mother and father seem beyond comprehension. Tonight, for the very first time out of court, you will hear their story. Tonight, watching our interview, you can reach your own verdict about them. We begin with the crime itself. A hot August night in 1989, the Beverly Hills mansion of entertainment executive Jose Menendez. He and his wife Kitty are watching television in the family room. Suddenly, a brutal volley of shotgun fire. Jose Menendez is killed by a close-in shot to the head. He has 5 other shotgun wounds. Kitty Menendez's body is riddled with shotgun pellets.
She had 10 wounds on her. She was getting blasted all over that room.
I killed my parents. Pardon me? Were they shot? Yes. They were shot? Yes.
The voice of Lyle Menendez, then 21 years old, who tells police that he and his brother Eric, then 18, discovered the bodies as they returned home from a movie. Lyle and Eric Menendez lied successfully for months. But if their crime was a horror movie, their undoing was the stuff of soap opera. Eric, in torment, confessed his crime to his therapist, Dr. Jerome Oziel. Lyle then also admitted to the murders. Their confession was overheard by Oziel's mistress, Judalon Smith, and she went to the police. Lyle was arrested in California. Eric, who had been traveling overseas, voluntarily flew home to surrender. 3 years later, the Menendez brothers went on trial for their lives.
I was just firing as I went into the room. I just started firing.
In what direction?
In front of me.
What was in front of you?
My parents.
And I remember firing directly at him.
You reloaded? Is that yes?
Yes.
And what did you do after you reloaded?
I ran around and shot my mom.
This is the woman who gave birth to them. This is what they did to their mother.
The jury heard tapes of the brothers' confession to Dr. Oziel. When their turn came, Eric and Lyle Menendez told a rapt courtroom that the murder of their parents was an act of self-defense. They said they were in fear of their lives from a controlling father who had been sexually abusing them.
If you're a web designer, here are 4 Wix Studio features you gotta know.
He raped me.
Did you cry?
Yes.
Did you bleed?
Yes.
Were you scared?
Very.
Lyle said his abuse stopped when he was 8, but that he didn't know until just before the murders that Eric was being molested too.
What do you believe was the originating cause of you and your brother ultimately winding up shooting your parents?
Me telling.
You telling what?
Me telling Lyle that,
You telling Lyle what? Was it you telling Lyle about something that was happening?
my dad had been molesting me.
The brothers' testimony was compelling and effective. Relatives testified on their behalf about incidents in which their father treated the sons harshly. though none of them could actually confirm the allegations of sexual abuse.
He didn't stop.
The jurors could not decide between verdicts of murder and manslaughter.
I find that the jury is hopelessly deadlocked, and the court declares a mistrial.
In August of 1995, now 6 years after their parents' murders, the Menendez brothers went on trial again. This time, there were no video cameras. Eric testified, but Lyle chose not to. Judge Stanley Weisberg again presided, but in a major blow for them, limited the brothers' claims to self-defense. There were far fewer grounds this time for a possible verdict of manslaughter. The jury deliberated for less than 4 days. The verdict? Lyle and Eric Menendez, both guilty of first-degree murder. The jury spent 3 more days deciding between life and death. The verdict here was life, in prison with no parole. The Menendez brothers have spent more than 6 years in this building, the Los Angeles County Jail. Eric lives in the identical cell next to this one. It measures 7.5 by 9 feet. Lyle's cell, in another wing of the jail, is slightly smaller. Both brothers are segregated from the general population. Each of the brothers separately is allowed up to 3 hours of exercise a week on the jail's roof. Eric and Lyle Menendez will be moved to state prison, perhaps even to separate prisons, this summer. Our interview took place in the jail's administrative wing, some distance from their cells. You may find Eric and Lyle Menendez to be cunning and manipulative, as their second jury seems to have, pronouncing them guilty of first-degree murder. Or, like many of the jurors at their first trial, you may decide that they are credible and that their story strikes a sympathetic chord. That is perhaps for you to determine. My job was to ask the questions, beginning with this one. What went through your minds when you heard that verdict? First-degree murder, guilty.
That I was going to spend the rest of my life in prison without any possibility of ever getting released. And you're devastated. I was devastated.
Could have been death. Did you think that?
I was terrified that they would give either one of us death, and it's scary.
It's important to you to stay together when you get moved to the state prison?
Very important. That is what's gotten us through these 6 years and through our life. The family that Eric and I grew up in, we had to be there for each other throughout, and it really created a bond that gets us through very rough periods.
Some people might say, why should we put them together? I mean, look what they did. They should be punished as much as possible. Let's separate them. What do you say to that? You know people will say that, some.
There's nothing to say to that. What we did, it was awful, and I wish I could go back. We will spend the rest of our life in prison, but if we're not put in the same prison, there's a good probability I will never see him again, and that some things that you cannot take, and there's some things that you can endure. With everything taken away, it would be the last, it's the last thing you can take.
Do you think the media has portrayed you fairly? Can you tell?
I don't know if anyone can be portrayed fairly in the media, who they are.
Well, let me say it. There are people, a great number of people, who think that you two are spoiled brats, that you are evil, that you are monsters. What do you say to them?
That's not who I am, but I can't defend that. Because I came from a family of wealth, it doesn't make me spoiled.
I would be surprised if anybody that was present at the trial and saw the whole thing rather than snippets on the news would feel that.
A jury found you both guilty.
Right, but I don't think you aren't guilty because they found you spoiled.
Or evil.
Or evil.
Just a normal I'm just a normal kid.
Oh, Eric, you're a normal kid who killed your parents.
I know.
And you still say you're a normal kid?
Well, I didn't have normal experiences, but I am. I did that, and there's not a day that goes by that I don't think about what happened and wish that I could take that moment back or change what happened. But it's hard to live with that.
Do you feel remorse?
Tremendous remorse. And I think
there's tremendous pain. I mean, from the second that I got back to the house after the shootings, I saw what happened and I said, this is wrong. This is awful. How could this have happened? I couldn't accept it.
You couldn't accept it, but you called the police. You pretended that you hadn't done it. You cried. You went off on a spending spree. I mean, we all read about it. You bought Rolexes, you bought cars, you didn't say, oh my God, what have I done, and turn yourself in.
Well, that's not really what happened.
Well, I've sort of stuck it all together, but.
Yeah, you did a good job at it. We got back to the house, the police were there, and it was a matter of telling him you did it or just saying, I don't know who did it. And that's what we did. And if I could go back, perhaps I'd say I did it.
And part of that started from the fact that we waited afterwards and the police did not come. And in that time that we waited, you know, we did make a bad decision to not have to.
We expected the police to be there. I mean,
You expected the police to come there and arrest you.
12 shots in the middle of Beverly Hills on a Sunday night, and no one calls the police. We're waiting at the house. No one shows up. And I still can't believe it.
So you called the police, but at that point, you had already decided
We had decided
that
not
you
to.
weren't going to say anything.
We were very stunned, and we felt that we would go to jail, obviously, and it was a selfish reason to just not want to have to go through that.
What about spending the money? You know, cars, watches, invested in businesses, the good life.
Well, it was the same life before or afterwards.
With more money.
With more money, but I didn't know what to do with the money. It got to a point where I have all this money and so much pain. I don't know what to do with it. And eventually.
I don't know, you're losing me. I would think that you would be in such grief that you wouldn't be able to buy Rolexes and invest in businesses. Explain to me, let me understand. I'm the public.
I don't think that it's understandable. I mean, people react to some traumatic event like that in different ways.
You went to your psychologist, Dr. Oziel, and told him that you had committed this crime.
I got to a point where I could no longer live. I felt that I was the worst person on earth, and it got to a point where I couldn't live with myself anymore, and I needed help. And so I went to him, and that is what the catalyst was for me getting arrested in Lyle.
You've had a lot of therapy.
6 years of intense therapy.
How are you different than the man who came in here?
I'm 6 years older. I'm a lot more mature. I came in here as an 18-year-old kid who didn't know anything about
What
life.
did you learn about yourself?
I learned I learned what love was about. I learned what love was about because of my grandmother, because of all my relatives who didn't say, I can't believe you did this. Instead, they said, Eric, I know who you are. You're not this type of person. You're not the type of person who could do this for no reason.
Have you had therapy, Lyle?
The same therapy, and it really works to just have someone you can communicate with that's willing to listen. All our lives, it was just sort of fending off things.
It almost sounds like prison was a good thing for you.
It was.
It was?
I mean, at first, I killed my parents, and I spent 6 months out there in horrible agony because I had done this. I mean, A year before, I told my mother how much I loved her. I could not have imagined doing this even a week before to her. I adored her. And then suddenly you're arrested and everyone can know you did it. And you can finally tell people, and it's a relief.
Lyle, you're looking at your brother like you almost never heard this before. Tell me how you felt.
You know, for me, emotionally being in prison conditions was really not, emotionally was not a shocking difference from the life we had lived, because we lived really a very stressful, fearful life. And to me, it was kind of like, I felt I should be punished. And it didn't feel good, but there was a part of you that feels like, that's right, it's better.
Squarespace's creative tools let you design a unique...
You get a lot of mail?
We still get a tremendous amount of mail.
Hundreds?
We've gotten hundreds, thousands over the years.
We asked your lawyers to give us a sample of some of your letters. A great many of them seem to deal with from people who have been abused themselves and relate to you. Lyle, what do you say to people who write to you?
A lot of people that have written were very, they drew a lot of strength from watching the trial and from seeing Eric and I. And I've gotten mail after the verdict, people discouraged. And I wanted to say to them to not lose hope because of this one case and this one verdict, very unique situation here. And that this does not mean that if they go get help, people won't believe them or people will treat them harshly or they'll be ridiculed. I don't feel they will be.
That's not to say do what we did. Don't do what we did, but don't be afraid of getting help.
People that want to reach out to social workers for help, but are ashamed or afraid.
Do you also get love letters?
Yeah,
You find that strange?
It's a strange phenomenon that a lot of love letters come in from people that don't know you at all.
Do either one of you have girlfriends? Do either one of you have someone who cares particularly about you now at this point in your life?
I do. I
You
have
do?
someone who I love very much and is a saint to put up with everything that comes with this.
Can you tell us who she is?
Yeah, her name is Anna Erickson, and I hope that we can get married, even though it's a very limited relationship because of where we are. The exchange of love and sharing, it keeps you in touch with yourself and softer, and otherwise you can become very hard and cold in here.
Is this someone you knew before prison?
No.
This is someone who began to write to you and meet you?
She wrote me many years ago, but and I've come to know her well, but just someone that I met through the mail.
And she wants to marry you?
And she does.
Eric?
No, not at the moment.
You're not going to meet a lot in prison, Eric.
No, I probably won't. It's hard. Lyle's more able to have that type of relationship.
Eric, you know that the prosecutor brought up the fact that you might have been a homosexual and that this might have caused some of the fury on your father's part.
Yes, he did.
I didn't hear about girlfriends.
They were there.
I guess what I just have to say to you is, are you gay?
No. The prosecutor brought that up because I was sexually molested, and he felt in his own thinking that if I was sodomized by my father, that I must have enjoyed it, and therefore I must be gay, and the people that are gay out there must be sexually molested, or they wouldn't be. Felt, and it was upsetting to hear, but I'm not gay. But a lot of gay people write and feel connected to me.
A problem at the trial was the gender bias, that because we were dealing with males and in an incest family, that there's sort of perceptions that, well, maybe it was something that he wanted, something that he allowed to happen, that he shouldn't be allowed to feel afraid because he's a male. I really felt that people might have seen this case very differently if it were a sister that I was protecting or that was involved in this, and not a brother.
You know, this whole business of abuse excuse, that you were abused by your parents, sexually abused, emotionally abused by this tough, unyielding father. But there are lots of people who are abused sexually and other ways, and they don't kill their parents. And you've been ridiculed for this abuse excuse. What do you say about it?
Abuse excuse is a word that Alan Dershowitz made up, not knowing anything about the case. To simplify it to its simplest degree, if a person is raped, man or woman, and she kills the man who raped her, is it an excuse that the reason she killed him is because she was raped? Of course not. I certainly never felt that what I did was justified or right. It was just a question of how wrong was it.
That was a big misperception about this case, that it was about justification or excuse. And my brother and I essentially pled guilty. That was very hard for me to hear the ridicule about that, because I really felt that Eric and I, we could have gone to trial like most people and just sort of, we weren't there, it wasn't us, and had that trial.
What do you mean we could have gone to trial? We weren't.
Well, you could go to trial and just say that I was, chipping golf balls at the time and I wasn't there. And Eric and I went to trial and said, we did this.
There were tapes.
Tapes became admissible because we said we did it. Lyle and I fought because he felt that telling the world that Dad was a sexual torturer was killing Dad twice, and he did not want to kill Dad twice. And he fought, and he said, I don't want to go up there, I'm not going to take the stand, I'm not going to do it. And then when he did, there was a great outpouring, but there was also people laughing at him, and it was strange.
Eric, you were able to tell your psychologist that you had killed your parents, but you were not able to tell your psychologist that your father had abused you?
Unless you've been molested, you can't realize how hard it is to tell.
Because of shame?
Because of shame.
The story continues now, the scene being set for murder. Describe your relationship with your father. What words come into your mind?
Brutal. Painful. Torturous.
Restaurant store.
30 chairs, non-squeak.
Restaurant store.
15 non-wobble.
And yet I thought that he was the most powerful and brilliant person I had ever met.
I was his firstborn son. That was very important to him. And my bond with him was, I thought, strong because we had been through so much together. But it was difficult to see the things that were going on. And
Things that were going on, that is, when you learned that he was sexually molesting your brother?
he had sexually molested me before I was a teenager. And it was a much different experience than Eric's.
Because you were little?
Because I was little, I guess.
You know, there are some questions that everybody asks, like, why didn't you run away?
I wish that I could have. I tried to run away when I was 12, and my father found me. He caught me and said, if you ever run away, I will kill you, I will find you, and I will kill you.
Suppose you left and you, I don't know what, became a waiter and moved away. You still thought he'd find you?
He would find me and probably kill me. I thought for certain he would kill me.
You still think that?
Oh, absolutely.
Did you love your mother or like your mother?
I loved my mother and I tried to help her. My mother was a person in a lot of pain, and she was alcoholic and she was suicidal.
Did she know about the abuse, the sexual abuse?
She knew.
And didn't do anything?
She knew, and it doesn't seem that she did anything.
Do you still think about the night of the murder?
Every day.
You both do? Tell me as clearly as you can why you murdered your parents that night.
First thing that comes to mind is terror. I was so afraid. A few days before, I had said to myself, I'm never going to let my father touch me again. After I told Lyle that it had been continuing on, I said to myself, I'm never going to let him touch me again. And just before the shootings, my dad told me to get to my room and that he would be there in a minute, and he was going to come up, and there was going to be sex, and it was like an explosion in my mind.
But you'd bought the guns. It wasn't something that just happened that moment. You'd thought about it.
No.
You bought the guns in advance. They just weren't in the house.
Yes, we bought the guns in advance.
So this
We
didn't
bought the
just happen
guns.
that moment.
We bought the guns. There was a series of confrontations and blow-ups in the house. My dad, when it first was revealed that I had told Lyle about the secret, my dad said to Lyle, "You're going to tell everyone, and I'm not going to let that happen."
Take me through your mind, Lyle.
I cannot separate and say this is why this happened. My father was threatening us, and so there was fear, but there was great, there was anger on my part, and my mother was aware of and had allied herself with my father, and there was a great deal of confusion. This happened all in just 3 days, and I wish I'd give anything to just turn back that one page of my life.
The other big question. You killed your father, who was molesting you. Why did you kill your mother?
On Thursday night before, in one of the explosions, I was running downstairs and I was crying, and my mother was on the couch and she had been drinking, and she said, "What's wrong with you?" And I said, nothing, you wouldn't understand. And she said, "Oh, I understand. What do you think, I'm stupid?" And she told me that she knew, that she had known all my life what my father was doing. And it was like I didn't even know who she was anymore. And I just saw Dad and Mom as the same person at that point. I saw them as a single person.
Really the first time that this secret about what was happening with Dad and Eric was discussed openly in the family in a very angry way. I don't know about Eric, but I completely lost control myself. And in that time, I didn't separate. I knew my mother and my father. It was just adrenaline and fear and anger. I
lost control.
There is no explanation.
But you had thought about this earlier because you had bought the guns several days before.
We knew that this could end, a violent confrontation could occur because my father had threatened my life.
You still think your father would have killed you for revealing the secret? You both still feel that?
There's no question.
Really?
I still believe that. I don't believe that he was in the process of killing us that moment, that evening.
Yeah.
But and I don't think that it might seem, because there are so few cases that come to the public's attention like this, that this has never occurred ever before in the country. And in fact, there are over 200 parricides a year that involve incest families. And so, I felt it completely then, and now I believe that, but I would not shoot my parents now, no matter what.
How now would you have resolved it? Now, almost 7 years later? What do you think you should have done?
I would have never told. I got Lyle into this. I went to him and I said, "Lyle, I can't live anymore with what's going on," and got him involved. He was away to go. They had bought him a condominium. He was going to Princeton. He had all the money.
So it's your fault for telling your brother?
It's my fault. And I got him involved and said, "I need your help." And 5 days later, my parents were dead.
So it's your fault?
That's completely my fault.
He was suicidal at the time, and it was just a last thing to reach out. And obviously who was going to reach out to. And I decided to confront my father rather than just sort of not say anything and just have Eric and I leave, which if I could go back, that's what I would do. I would just say, Eric's old enough now, he wants to leave.
Have you forgiven yourself?
I don't think it's possible.
Lyle, are you at any kind of peace?
More so than maybe Eric, because at this point, for some reason, well before the verdict, I was resigned to bad things. And I have, I think, found a place where I can look forward and try to have hope and share myself more with people. And
Hope of what?
hope of living a life that I can be more proud of.
How in prison?
You're confined, but there must be, even just in writing, people that need help.
If you can help them and convince a single person that has been through our situation that the last thing in the world they should do is act out violently, then you find meaning in your life.
If you could say something to your mother and your father, I'm sure you have in your own minds, what would you say?
I am so sorry. I forgive them completely for anything they have done to us. If I had one wish, it would be able to have one conversation with them or to change places with them.
I hope someday that I can be with them and have some sort of conversation about what happened. It is one of the awful things is that we couldn't communicate that weekend, and I can't. And just that I love them, and that I believe, despite everything that happened, that they really loved us, and that things just went awry.
Our interview is over. Deputies now arrive to take Eric and Lyle Menendez back to the cell blocks. They were handcuffed and chained for the long walk back. Their legs had been shackled throughout the interview. This had been one of their infrequent opportunities to see one another in jail. The guards would now take each of them to their separate cells and to the certainty of the rest of their lives in prison.